and it is one that has gained popularity, I would say, even within our state recently. We'll be talking tonight about all the different decision-making options, including supported decision-making, which is really up and coming. And it is coming up because of the many questions that come up in our state about whether or not somebody that turns age 18 needs a guardian or a conservator. And the goal of this presentation this evening is to really talk about all of the different planning options that are available to families and the importance of making sure that all of the options are considered before a decision is made. Andrew, anything to add before we kick it off?
No, please put the questions in the chat. I'm going to answer some as, we go along, help field them. You interrupt Kathleen as I, feel like doing. I'll add in, a few comments. We try to make this, practical. If you want to read, like the laws, you can go on the state of Connecticut's website or read boring legal documents, but we want to help everyone leave away with the correct information, but also in a way that is useful and helpful. That's most important. We're both on the Supported Decision-Making Coalition for Connecticut. So we're both passionate about this. We've been on for a while now. And the other Chris from, I think it was Fairfield, was on with us before he retired as well. So we're happy to be here and provide some good information.
Andrew, I just wanted to jump in, by the way. If anybody was like me 2 years ago and had no idea what the chat is, I just don't want to assume that everybody knows. So if you're on the bottom of your screen and you see the two little heads, if you will, for Google, it's the little thing that looks like a tablet or a little script to the right of that. If you clicked on that, you can then type in a question, and that's called the chat. And if I know it's difficult to do with phones, I know some of you guys are in your cars, but it's easiest way to have the questions go through that, so then Andrew and Kathleen can see the questions and field them, which will also take down in time as well.
Great. Okay, very good. So everybody can see the presentation and the presentation alone?
Yep.
Okay, great. Okay, so let's get started. Just see here. Okay, perfect. All right, so we start our presentation with the magic number, which is age 18. And age 18 is a magical number in the realm of really any child, because that is the age at which you become a legal adult. So in the context of individuals with disabilities, before age 18, parents are accustomed to fully participating in doctor's appointments and making medical decisions, therapist appointments, and really principally and importantly, PPTs and the educational process. So as a child reaches the age of 18, there becomes a shift in that the parents no longer have the automatic legal right to continue in making medical decisions, financial decisions, and educational decisions. And you see those on the screen are represented medical decisions with the heart and money with the money, and then we have a little graduation cap for school. So we try to keep it symbolically a little easy to follow. So when someone turns 18, there's a legal barrier between them and their parents, which can be overcome by looking at different decision-making tools that will enable the parents to still participate in decision-making for their child to whatever extent appropriate, whether it be supporting the child themselves in their decision-making, or whether it be the parents continuing to be the primary decision makers on the child's behalf. So I always like to start with the why, as does Andrew. Why is it necessary for individuals with disabilities to use the least restrictive decision-making tools that are available? And the principle of self-determination really applies here. Perhaps this is something that's come up in the PPT process, but it's the concept that people with disabilities, just like people without disabilities, have the right to control their lives and have authority over the resources that support them. So what we're talking about is the freedom to choose. And this freedom of self-determination can be achieved not necessarily in a vacuum, but with the support of other individuals. So this concept here is to look at decision-making tools in the context of whether an individual with a disability, to what extent they can participate in decision-making that's going to shape the course of their lives. And the goal is to make sure that they have maximum participation in those decisions.
And I think it's very important to also do, the school system has a least restrictive environment, and you just want the least restrictive option. It's much easier to go more restrictive than to undo restrictions. I mean, a common example would be, Britney Spears and the conservatorship in the media has brought a lot of that to the attention. But even if every party is willing, it can still be a process. So even from just the ease of see if the least restrictive option will work, and if it doesn't work, then you move to the next one. So again, always, start there. It's important to also remember if, the adults here, when you were 18, did you make good decisions? I'm not even sure I do now, right? The quote legal is, do they make, are they incapable of making any decisions, not good or bad ones, right? Sometimes an 18-year-old or 20-year-old is a 18 or 20-year-old, just like with or without a disability, and they like video games or to stay home or to not do things. So it's important to try to have that perspective and just look at what do you want to accomplish, right? So what is the goal? Because maybe there's better ways to do it.
Perfectly said. Yes, so the principles of self-determination are promoting choice, promoting dignity, promoting control to whatever that is available for the individual. So what does the law require? This is really important because I think a lot of people assume that if there is a disability and that is impacting someone's cognition, like an intellectual disability, for example, that there is a presumption that that person lacks the ability to make decisions. And that simply isn't true. Connecticut's law says that someone is competent if they're able to make a decision independently or with the assistance of others, family, friends, and other private or public resources, so long as that decision will avoid serious physical injury, illness, abuse, or financial harm. So anytime that a court appoints a conservator or a guardian, they have to find by strong evidence, called clear and convincing evidence, that it is the least restrictive decision-making tool available to them. And importantly here, just as Andrew said, what we're looking at is decisions that will avoid serious physical harm or financial harm. It's not whether or not somebody might make a bad decision that will have slight harm. So it's important to keep that in mind. So here is the spectrum of decisions being visually represented, and it is going from left to right. We're going to talk about each of these tools this evening, from the least restrictive planning tools available to the most restrictive. So we're going to start off by talking about advanced directives and power of attorney. Then we'll speak about supported decision-making. And then as we move along the spectrum, voluntary conservatorship of person and estate. And then lastly, involuntary conservatorship of person and estate, as well as guardianship. Okay, so first, what is an advance directive? An advance directive is a legal document created by an individual who is an adult, so 18 or older, that is able to understand the general nature of the document and to express their wishes about healthcare decisions. So what this looks like with a client that I might be working with. So I have many clients who are turning 18, and when they turn 18, they sign these documents, and how I question them to see whether or not I feel comfortable with them signing the document is ensuring that they understand that it's a document about medical decision making and that they have a general understanding of all of the different elements of the document, asking who they would like to appoint to help support them in making medical decisions, making sure that they trust that individual, and that the individual has the ability to express preferences about their medical care. So individuals that can meet all of that criteria would sign an advance directive. And what you're doing in signing this document is naming healthcare representatives. So in the context of an 18-year-old, what we're typically talking about is an individual, a child, naming their parents as their healthcare representatives so that their parents can continue to help make medical decisions for them. And the circumstances in which the parents would help to support those decisions are two. One would be if the child, adult child, is unable to make a medical decision. Usually we're talking about incapacity. There was an accident and the individual has lost consciousness, or they are experiencing a hallucination or a bout of confusion or dementia. Those are the types of situations where a healthcare representative steps in and makes a medical decision for the individual. Or predominantly, in what the context typically arises in for school-age individuals, is when the person requests assistance. So that might be going to the doctor's office and asking the doctor to talk to your parent, or having your parent be the primary decision maker relative to the medications or the medical interventions that an individual might have. So basically, the individual defers to the parent to continue to help make those decisions.
So a great example would be my wife, who does not have a disability. My mother-in-law is a nurse. She is also my healthcare proxy because, well, she'll pull the plug on me, no problem, and that's my wishes, maybe even too soon. But when it comes, but my wife, if she goes to the doctor, her mom's a nurse. She'll ask her mom, "What do you think? Like, what you know more than I do," and her mom will give her opinion. So this is, we all have that person who's maybe good with cars, right? Or good with, something that you're not, and you ask them for advice. And so really this is saying, it's like having the parent has been there all along with the medications, has a lot of the health information, and very much the same way that, my mother-in-law knows more than my wife because it's her job, her profession. Although that's not required, it's just the example here, in order to just, help the individual make that decision, my wife is still making the choice, for better or for worse. She's just getting a quote, second opinion and somebody who's able to help her. And that's how this really should be looked at, right? It's still up to the individual. And I'll stop before I get ahead of where Kathleen was going. So.
Well, no, that's perfect, because you'll see this on every single slide. You say, whose wishes win? And the answer to this question is really what tells us whether it's a least restrictive or a most restrictive tool. So in this case, the individual's wishes, so the child, win if there's a disagreement between them and their healthcare representative. Oh, I'm sorry. Somebody might need themselves on mute. Thank you. So this is a document where if there's any sort of discrepancy or disagreement between the individual and their agent, the individual is always going to be in the driver's seat, so to speak, with medical decisions. They're not giving that decision-making authority away. They're simply inviting other people in, as Andrew said, like a mother-in-law, to have some sort of guidance and advice and be able to legally participate in conversations that have to do with someone's medical welfare. All right. So the other side of that coin is a power of attorney document. So an advance directive is going to deal exclusively with medical decisions. A power of attorney is a legal document created under the exact same circumstances by someone who can understand the general nature of the document and express their wishes, but in this case, relative to financial, educational, and other legal decisions. That's the domain of a power of attorney. In this document, the individual names agents, usually again in this context, parents, to make financial decisions, legal decisions, including educational decisions, on their behalf if the individual is unable to make, a financial decision, not a medical decision, but a financial, legal, or educational decision, or the individual simply requests assistance. So this would be an example where, in a PPT, for example, the individual can sign a power of attorney when they're 18. That includes educational decision making. That allows the parents to continue to participate in the PPT process, and the child can defer to their parent and say, I want my parents to still continue making decisions about my IEP, about my goals and objectives, so that while the individual child is still participating in the PPT and their opinion is still voiced, that they can still defer and rely upon their parents to be the primary decision makers in terms of what's actually going into that educational plan.
And this is a lot more common than a lot of people might realize. I have hundreds of limited power of attorneys as a financial advisor because somebody may hire us to make investment decisions, to place investment trades, and to manage money. In order to do that, we have a limited power of attorney where I can help, make some of those investment decisions and, again, still with the wishes and the best interest of the person. So this is just a lot more common than and less scary than a lot of people, might realize or think, and not just for people with disabilities.
Yeah, it's a great point. Both of these documents, the advance directive and the power of attorney, are legal documents that are part of any estate plan. So that means any person over the age of 18 should have a power of attorney and a healthcare directive, presuming they have the capacity to create those documents. One of the things that's really important about both the healthcare directive and the power of attorney is that they are what's known as durable, meaning that they would endure through someone's incapacity. So if somebody, as I mentioned earlier, lost consciousness or had a traumatic brain injury, these documents then allow the agent to be the primary decision maker. And that's a really important way to protect an individual's preferences, because without these documents, if someone loses capacity, we have to go to the more restrictive options in the court in order for somebody to have the legal authority to make medical and or financial decisions. So these documents endure and make sure that no matter what happens, the individual, if they can't make decisions, that somebody that they know and trust has been appointed to step in. And once again, whose wishes win? Because this is a least restrictive decision-making tool, the individual's wishes are always going to win under the power of attorney because they remain in control of the decisions. All right, so now we're on to supported decision-making, which is still a least restrictive intervention. And I like to think about supported decision-making as an additional legal tool to a power of attorney and an advance directive. It's not something that I would say exists unto itself. It's something that you would pair with the advance directive and the power of attorney because it really complements those planning documents. Supportive decision-making is more than just a thing. It is actually a process. It is a collaborative process that promotes an individual's ability to choose. So we're going back to those initial principles of self-determination, an individual's ability to maintain control and participation in the choices that impact the course of their life. So with this process, an individual seeks the advice, or the counsel or guidance of others before making a choice. It's a way of formalizing what many of us do every day naturally. Andrew mentioned his mother-in-law. His wife, Andrew's wife, naturally goes to her mother when a medical decision comes up and says, "What do you think here?" Likewise, individuals go to Andrew for financial advice or me for legal advice, because we all have things that are outside of our realm of expertise or outside of our comfort zones. And the fact that we need to rely upon other people to help us make decisions doesn't make us incompetent, it just makes us human. So it's recognizing that people with disabilities have the same needs and the same abilities to act and find resources within their natural circle of supports to help them to come to decisions that would be beneficial. Supported decision-making can be informal or formal. Informal supported decision-making agreement is just, supported decision-making is just as I mentioned, it is organic reliance on natural supports for assistance with challenging life choices. So, for example, an individual with a disability might think about and have conversations with their parents about what areas they might need support with. Perhaps it's medical decision-making, financial, perhaps it's social decisions, employment decisions, housing choices. So the individual can think about what are all of those areas where I would need support and who would I go to if these questions came up. Nothing needs to be written down with informal supported decision-making. It's just setting up a framework for how a choice will be made if a question comes up in one of these challenge areas of their life. Formal supported decision-making is when somebody actually enters into a written agreement with supporters or the people that they have chosen in their circle of support to help guide them in those questions that might come up where they need assistance. So we'll go through what those tools look like, but it is important to recognize that supported decision-making is more than just a document. It really is a philosophy and a way of thinking about how decisions and choices are made. So whose wishes win? Well, under a supported decision-making agreement, individuals are simply supporting the decision of the individual with the disability. They are not empowered to step into their shoes and make a choice for them. This is an example of how an individual can look to evaluate the areas in which they might need support. This is a document, I believe, from the American Civil Liberties Union that is meant to help an 18-year-old, for example, go through the areas where they are independent, or the areas where they need support, or the areas where they feel like they need more than just support. They need to depend entirely on someone else. And I would encourage everybody, before choosing any sort of decision-making model, to go through this, because you may be surprised at where you end up in terms of the things that an individual can do alone versus with support versus with total assistance. And these are just more examples of the different domains, staying safe, home and friends, health choices, that an individual can consider where they might need assistance. And this is an example of a supported decision-making agreement. This is from the American Civil Liberties Union. There is also, and I can send this around with the PowerPoint, there is also a supported decision-making agreement that the Connecticut Supported Decision-Making Coalition put together, which follows this pretty closely, but it's a different example of a template that an individual could use. In Connecticut, we do not have a set form for this document. It's basically whatever fits in the individual's particular circumstances, but the overall structure would basically be who's creating the document, what their areas of support are and who they're appointing to support them. And then that document would be signed by the individual as well as the supporters, acknowledging that they consent to provide assistance. I did highlight here, I am including the following forms to this agreement: a HIPAA authorization and an educational release. The reason I did that is because supported decision-making as a written agreement is not within our Connecticut laws. So that means that if you give this agreement to a school or a doctor's office, it's not necessarily going to carry the weight of the law in the same way that a power of attorney or a healthcare directive would. So there might be some other releases or forms that these individuals would need in order to be able to actually release information legally, like a HIPAA release for medical information or an educational release for educational decision-making.
So one point, or a point I really want to mention, is don't wait on Connecticut to pass a law. It doesn't matter, essentially. It matters, but it doesn't matter to you individually. So what I mean by that is Connecticut making it official will just mean, well, it'll mean a lot of things, but it'll mean more awareness, a more streamlined process, more recognition. But at the end of the day, when you go to the doctor's office, right, they still need you to fax, right? Like they're not necessarily very up to date on all of the things. So even if Connecticut legalized it today, you would still want that power of attorney, the healthcare directive. Those legal documents are simply how we accomplish supported decision making. I still call it supported decision making. It's just a little more informal, right? With no official process. You're still accomplishing the same thing with similar documents. So, for example, I did a lot of presentations with Fairfield and I think Greenwich on ABLE accounts well before Connecticut had them. It was a very similar conversation, right? And what we actually found was when Connecticut had their ABLE account, we got a lot of calls. Oh, this isn't very good. Can we use another state? So, very similarly, there's no advantage to waiting on Connecticut, to pass supported decision making. Go ahead, you can do it now. It's not going to be any less or more valid down the road. And even if Connecticut does have it officially, you're still going to want those old school legal documents, lack of a better term, because, the hospital, everyone, like I said, they're still using computers from 1990 and fax machines. It'll take them a long time to catch up anyway. So.
Yeah, that's a great point. And I'll also add that the healthcare directive and the power of attorney, remember we talked about those being durable, meaning if someone loses capacity, you've already appointed someone to step in and be a primary decision maker. If someone loses capacity and they have a supported decision-making agreement, there's really nobody that can help make a decision absent those other documents, because this document only exists if the individual is able to make the decision. It only exists if people are supporting a decision, not making a primary choice. And to Andrew's point, supported decision-making, as I mentioned, is informal as well as formal. Within my office, I prepare supported decision-making agreements regardless of the fact that it's not in the Connecticut law. The Connecticut law is not going to make this a valid document. It's only going to, as Andrew said, increase the recognition and provide probably some rules and parameters around how it would be interpreted and enforced. But it's still a valid document today. It's basically a contractual relationship between the individual and their supporters. This is just an example of a consent form for the supporters to sign, saying that they will honor the wishes of the individual. Okay, so that's supported decision-making. We're moving on in the spectrum to a more restrictive tool, and that is voluntary conservatorship of person or estate. Conservatorship now involves the probate court. The probate court is usually in the town hall in the town where you reside. And it is the court where an individual would go in order to have someone appointed to make decisions on behalf of somebody else. So the legal documents that we discussed, the power of attorney, healthcare directive, and supported decision-making agreement can all be done outside of the court. Conservatorship can only be accomplished through a court. So it is a court order that names one or two individuals to make decisions on behalf of someone with a disability. The court order is going to identify the decisions that the conservator is permitted to make, like for a conservatorship of person, decisions about personal welfare, like where they live, what education they receive, employment, medical decisions, and a conservator of estate would manage financial decisions. It's possible for someone to have just a conservator of person or just a conservator of estate or both. It really just depends on what the individual needs. The way that this works is that the individual signs a form, which is called a petition, requesting that the court designate certain individuals to make decisions on their behalf. So this is typically going to be parents. And the individual, because this is voluntary, can terminate the conservatorship at any time with a written notice to the court. They simply just write on a piece of paper, I want to end my conservatorship, and 30 days later, the conservatorship would be ended. So importantly, the person asking for the conservatorship is the person with a disability. So this would be someone that, as we were looking at that checklist document of what they need help with, what they can do independently, this is someone that probably would be checking off, I want someone else to handle all of these decisions for me, as opposed to somebody saying, yes, I can make this decision, but with support. When conservatorship is implemented, even though it's voluntary, once that conservatorship is in place, the individual's right to choose is given to the conservator. So if parents are named as the conservators to make residential decisions or educational decisions, if there's a disagreement between the conservator and the child, the conservator, the parents, their wishes will now win and override the child because they are now the decision makers. Of course, that can all be changed with a written notice to the court from the child, and 30 days later, the conservatorship goes away. But for that time that the conservatorship is in place, the liberty right to choose of that individual with a disability is relinquished and given to the parents.
It's important to note that even if it starts off voluntary, it can still be hard to undo. There can be lasting effects that go, decades with a voluntary conservatorship. And that really goes back to the beginning with why are you looking to do it? If you're looking to help make medical decisions, not necessarily, the best answer, right? Again, start with the least restrictive and move on. But you think, oh, if it's voluntary, well, it's not quite so simple to undo it. So, just keep that in mind as we go forward.
All right, we are now in the most restrictive realm of the spectrum of decision making with involuntary conservatorship of person and estate. So this would be a situation where the individual with a disability lacks the ability to even appoint somebody else to make decisions for them. So in this case, the people that are looking to be appointed to make decisions, so usually the parents, would be filing a petition with the court to be appointed as the conservators for their child. Ultimately, it works similarly once it's created to the voluntary conservatorship of person, meaning that the court is going to issue an order appointing a conservator of person, a conservator of estate, or both, depending on what the individual needs in particular. And the conservator is going to have all of the duties outlined in that court order, meaning that they now have the right to choose and make decisions for that individual. In this case, because it's other people asking the court to appoint them to make decisions, there are a lot more legal safeguards in place for that child, because essentially their rights are being taken away from them as opposed to them voluntarily giving up their rights. So when rights are being taken away from an individual, there are a couple of things that need to happen. One is that the parents would need to submit a medical physician's evaluation to the court, and there is a probate court form that a physician can complete within 45 days of a hearing. So it has to be a recent medical evaluation, and that physician, not an APRN, not a PA, it's got to be a physician, has to determine that the individual is incapable of making decisions for their personal welfare or their financial welfare. In order for the court to appoint a conservator involuntarily, they need to determine that by clear and convincing evidence that the individual lacks the capacity to make these decisions, and they also have to find that lesser restrictive options were considered but are not appropriate. So it's a high threshold to demonstrate that involuntary conservatorship is the right option. But I will say, just because it's the most restrictive option doesn't mean that it's not appropriate for some individuals. So we really have to look case by case to see when this would be an appropriate tool. Another protection is that a state marshal will have to serve notice to the individual with a disability that a hearing is going to be held on conservatorship. That is on the record at the hearing to demonstrate that the individual had the ability, had the time and the notice to prepare and contest or rebut the conservatorship prior to the hearing. And in that vein, the individual is also appointed an attorney, and that attorney will usually meet with the individual prior to the hearing to understand what their preferences are. In many cases, involuntary conservatorships, though they're involuntary, they're not contested. So in many cases, the individual is able to indicate to whatever degree they're cognitively able that they either don't disagree with the conservatorship or they trust their parents. In some cases, the individual might not be able to communicate their preferences at all. But it's the attorney's job to do the best they can to understand what the individual's preferences are and to communicate them to the court.
Kathleen, if it's not contested, why wouldn't you just do voluntary instead of involuntary if the individual is not disagreeing with the decision?
Because the voluntary versus the involuntary doesn't mean whether the person agrees or disagrees. It means whether the person is capable of choosing. So if someone is capable of appointing a conservator or capable of recognizing that they don't want to make decisions, then they would be doing a voluntary conservatorship. But if somebody is not capable of making that decision or that distinction, then it's not that they contest the conservatorship, they just lack the capacity to be able to appoint a conservator or express a preference at all.
My 4-year-old daughter, she had breakfast cake every day, 3 days in a row, which, by the way, is cinnamon rolls. It was in a cake from Costco. I didn't know how else to describe it other than breakfast cake. She would say yes, right? Or not, do you want help, right? But she's not legally capable of making that decision. Mediocre example. I won't even go bad, but yes. So.
So in the involuntary conservatorship realm, the conservator's wishes are going to always outweigh those of the individual with a disability. The additional safeguards in place here are this conservatorship has to be reviewed every year. meaning the conservator needs to submit a report to the court saying this continues to be appropriate and here's why. And every 3 years, a physician has to submit another medical evaluation stating that the disability continues to impact the person's ability to make decisions. Lastly, we'll talk about guardianship. So guardianship, and I should have mentioned this earlier, conservatorship is usually implemented when an individual has an IQ of 70 or above. Guardianship is only ever implemented for people with an intellectual disability, which in Connecticut is defined as someone with an IQ of 69 or below. So guardians and conservators are basically given the same type of role. If someone has a guardian versus a conservator, it really just means one person has a lower IQ than the other, but the actual functionality of that guardian or that conservator's role is going to be virtually identical. So in this case, we're talking about other individuals like parents petitioning the court for guardianship for a child with an intellectual disability. And they can ask the court either to name them as plenary guardians or limited guardians. Plenary guardianship means that the individual is not capable of making any decisions about their welfare, about their education, employment, and that the parents really need to be making these total decisions for them. Whereas limited guardianship says, our son or daughter is capable of making some decisions, but not others. And so the court would limit the decree to just those areas where the individual lacks the ability to make decisions. So in this case, because it is also an involuntary process, other people, like the parents, are initiating these proceedings. Like the involuntary conservatorship, a marshal will serve notice to the individual of a hearing, and the individual will be appointed an attorney to express and represent their interests at the hearing. And again, if there is a discrepancy between the individual and the guardian's wishes are going to win. Guardianship in and of itself only pertains to personal welfare, like all of these domains that I've listed on the slide. It does not automatically include financial decision-making, and many parents are surprised to learn that. You actually have to fill out a different additional form if you want the guardianship to include financial decision-making authority. And a guardian in Connecticut is only permitted to manage up to $10,000 on behalf of their child, basically. If the individual, the child, has more than $10,000 in their own name and the parent needs to manage that money, then in that case, the individual would have a conservator of estate. So a conservator of estate can manage money up to any amount, whereas for guardianship, it's just up to $10,000. It's one of those oddities in our law where it doesn't really, that $10,000 cap doesn't really make sense. It doesn't really make sense as to why you would need a conservator of estate versus a guardian for financial decision-making when the role is basically the same. But those are the lines that we've drawn in the sand.
A common issue where we run across this is the state of Connecticut picked the ABLE Alliance for ABLE accounts. And they have a more strict requirement than the law requires to open an ABLE account. So we'll get some parents contact us and say, they wouldn't let me open the ABLE account. I have guardianship. They say that's not enough. They say I need conservatorship. Even if the ABLE account is below $10,000, I've spent hours on the phone. I said, that's Connecticut. You should go to Ohio stable account. You can open it as a parent. And we get an email back in 15 minutes. I should have done that hours ago. just want to mention that that's a common, where this comes up quite a bit. And Kathleen, there is a question. I don't know if you saw it or you're going to get to it later.
I didn't see it, but let me just make one more point before I answer that, based on what you just said. Anytime someone is considering financial authority, I always caution clients to think about where the money is held and how it's managed, because there are different ways to manage money on behalf of an individual with a disability that don't involve conservatorship of estate or guardianship for financial decision making. So I guess the question is, well, why wouldn't I want that authority if I could have it? And the answer is, number one, because it is taking away an additional right, perhaps needlessly. But number two is that there are reporting requirements to the court. Once you have financial authority, you need to tell them where every penny went through financial reporting, usually once every 3 years. So that's time and money, because you have to pay filing fees to the court, and then the attorney for the child has to get paid as well. So the different types of tools that can help to manage money without the guardianship or the conservatorship would be, as Andrew mentioned, an ABLE account in the right state allows a parent to manage the money in that account on behalf of their child. A special needs trust, the trustee has the ability to manage the money as opposed to the child. And for Social Security purposes, oftentimes a parent would be named as the representative payee to manage the Social Security for their child. In most cases, I have clients that are 18, 19, 20, and the sole resource of the child is Social Security, SSI, or Social Security Disability Insurance, SSDI. And in those cases, I say, well, if you're appointed as the representative payee, you have all authority to manage the money. There's not an additional need to get authority through the court at this time, and then welcome unto yourself additional administrative requirements with the court. So always thinking about the global picture and narrowly focusing on what is the exact problem I'm trying to solve, I think will always yield the most productive results and least restrictive results. Andrew, yes, what is the question?
So before the question, I want to mention, just a common example. We talk about like least restrictive, and there's some examples where, it's important to some, but not others. But one of them is, a small business, right? And that's becoming more and more common. And if you can't make any decisions, then you can't own or run a business, right? Which is, again, whether it's, making T-shirts or, a hot dog cart or selling something on Etsy or dog walking business. These are all examples, again, that, or blogging that we're running across. So if an individual has anything other than a form of supported decision-making, they can't own a business because they can't make any decisions. And we do find that owning a business is also just it's a great path, right, to, happiness and, as much independence as the individual can have. So just a very super practical example of something they will not be able to do. Also, I don't know anyone who likes going to the DMV. Like, let's say they can drive and you have conservatorship, well, they can't make those calls. They can't do those things. You're giving yourself, as a parent, a lot more work because the individual can't, call the DMV to get it fixed. They can't call the insurance company. They're more like a minor. They can't do anything instead of being able to ask, help. So unless anyone really likes waiting on hold with Comcast all day, for example, with the cable bill, I kind of do, but that's because I like to lower it for people, right? There's just some things where you don't realize how much you're taking away. I just want to add that. The question is, what happens when the conservator passes away? And I know we were going to get to that, Kathleen. I don't know if on a slide.
It's not, no. Thank you. I would have skipped it altogether. So for both conservatorship and guardianship, there is the ability to, when you initially petition the court, to name standby conservators or guardians. So if there's a sibling or an aunt or an uncle that would be a backup if the parents passed away, then you can designate them from the start as a backup, and then their authority would ultimately come into play when the primary decision makers pass away. Some people, and many people, have this worry, well, what happens if I don't have anybody, if I don't have someone to name as a backup? And in those cases, what you're often looking at is the court appointing a backup who is an attorney or a professional conservator or guardian. And the concern there is always that there's no relationship that's been established, there's no trust that's been established, and many people would be reticent to have someone that they don't know, that their child doesn't know, step in when they're no longer around. I do recognize that in some cases, when guardianship or conservatorship is appropriate, that can be very stressful for families. And one of the things that I recommend is trying to identify individuals, whether they be friends, whether they be natural supports, or whether they even be some of these professional individuals, and establishing a relationship and getting to know them and involving them in the child's life before the parent is no longer able to be in that role. It's not easy to do. It does take effort and planning, but it's something that I think helps to ease a lot of concern when people simply don't have another alternative in place. All right, so that is the conclusion of the presentation. In summary, we talked about the spectrum of decision-making options when an individual turns that magic number 18. They become a legal adult, and parents are no longer naturally able to make decisions for their child. Leading up to age 18 and at age 18, the individual in the least restrictive tools can create an advance directive for medical decision-making, a power of attorney for financial, legal, and educational decisions, and supported decision-making for really any area where the individual needs assistance. And then moving along the spectrum, if an individual is not able to be the primary decision maker, they might voluntarily select their parents or other individuals to manage their personal welfare and their money. Or the individual may not be able to express a preference due to their cognitive abilities, and in that case, an involuntary conservatorship or guardianship would be the option selected.
There's a question, and I just want to add another comment as well. So one important thing, and something that we run across, is, the probate court is where you can go for conservatorship or guardianship. And it's important to think of a couple things in regards to the probate court. Couple, I mean two. The first is many of the probate court judges are in Connecticut. We elect them, and they come from many different backgrounds. So they could also have a great deal of experience in corporate law, but depending where you get them in the election and the cycle, they may not have a great understanding of supported decision making at this time. The other thing is the probate court can't give legal advice. They are not going to give you, the least restrictive option, right? If you go to a restaurant and you want, steak, they're going to give you steak, right? If you go to the probate court and you say, I want conservatorship, I want guardianship, I meet the criteria, they're going to help you do that. They're not necessarily, they can't, right, Kathleen, advise on your legal options. You all hear those TV ads. This isn't legal or financial or tax advice. It's not, it's very similar. You go there, they are not providing any legal advice, but but I think a lot of people interpret it as, well, they should. It's the probate court. They're helping me. I'm asking them what to do. But they're not telling you of other options. It's not because they disagree with them. It's because, they can't. And there are a couple more questions, Kathleen, if you want to see the chat too, but you might have a comment on what I just said.
No, I think that's a great point to bring up. I'm going to stop sharing my screen in a moment so I can see the gallery for questions, but here are some resources that you can look at to learn more about each of these documents. And as I mentioned, I can send to Chris and Michael as well the Connecticut Coalition for Supported Decision-Making Guide on Supported Decision-Making as an additional resource. My office is in Glastonbury, and my phone number and email are there, and Andrew is currently in Farmington, and his information is there as well if you have any questions that we don't get to this thing.
Well,
okay.
So Kathleen and Andrew, thank you so much. I do know we have a couple of questions in the chat, so maybe we should try to jump in and start to answer some of those questions.
Perfect.
Let me see. Does a backup person have to live in the same state as the individual?
No. No, and oftentimes, especially today, things can be done on WebEx, things can be done by conference call. What's important is that they have the ability, though they live in another state, to be involved and make decisions for the individual.
Okay.
And just want to add to, and Kathleen and I have a case, she knows which one I'm thinking of. Sometimes you don't want to pick the most responsible individual as a guardianship or trustee. The lawyer may not make the most sense because lawyers are very busy. They're here giving presentations at 7:30 at night. And lives of their own. So when you think about all the responsibility and all the time you spend as a parent, sometimes don't necessarily think of the person with the busy corporate job, because remember that they should be available for that individual. And that's something that makes sense, but at first glance would seem counterintuitive, that we run across quite a bit.
Okay. Okay, what if the secondary guardian dies before the parents, or if the parents change their mind for whatever reason and want to change their original choice of secondary guardian?
All of that can be accomplished. Changes can always be made. It just would have to go through the probate court. You'd have to submit further documentation to make those changes.
Okay. Can a person you elect for volunteer conservatorship start a business?
Yes, I would imagine that they can. So voluntary conservatorship is similar to guardianship in that you have to just carve out what the conservator's duties are versus what the individual retains. So the court order is going to say, here are all the things the conservator is now in charge of. So that decree would expressly need to exclude the ability to manage a business.
It can get really complicated also from the aspect of, well, what if the parent's running the business and then paying the individual? But if the individual is also receiving government benefits, we find that it can be a lot easier to maintain them if the individual is self-employed, to have their own. So the answer is yes, potentially, but it's a lot more complicated. There's a lot more issues. And if the individual is capable of starting their own business, then they're capable of making decisions. So very bluntly, they really shouldn't have conservatorship or guardianship. Depending on the business, there are of course exceptions, but I would very much rethink conservatorship or guardianship if they really are starting a business.
What about going along with this? Can I put an existing business under my child, son or daughter?
Can I put in? I don't.
I've run into this. You should. That is an example where an overall plan is really important. There was on the CT marketplace over the weekend, like a portable axe throwing business. Just because I could go out and buy it doesn't mean I should. So the answer is yes. Should you? Probably, almost certainly not. And that's really where you should work with someone like Kathleen and myself on what are your overall goals and what your planning is. There was also a go-kart for only $400 that went 50 miles an hour. The issue was the brakes didn't work. Who cares, right? So,
going along with that, with Kathleen and Andrew and your expertise, some of the folks would like your contact information posted again. If we can kind of put up that slide, and maybe folks can take out their cell phones and take a picture, or I certainly have your contact information as well. If we could put that slide up for another minute or so.
Sure.
And then I actually have a question or two, and then I know Michael would like to talk a little bit about maybe another parent seminar in May to talk about some of those ABLE accounts that Andrew spoke of several times. So there you go. There's the contact information for Kathleen and Andrew. They're both from the greater Hartford area, but I'm sure they'd be more than willing to help if you have questions specific to what our discussion was tonight. So Kathleen, I have a couple questions for you.
Sure.
All right. So just from and I thought Michael, I think will agree with me. So just from the perspective of a school district that has to advise families, at age 17, when their child is age 17, that, the transfer of rights will occur at age 18, unless they want to pursue one of these options that you talked about. And so many times, yes, we will say you need to contact probate, and you're right. Probate's not going to give all this information that you gave tonight. What would be your suggestion? Because I know Michael and myself, we were asked constantly, well, what would you do? Or what do you suggest? And as a school district, we're not attorneys. We're not probate judges. What would you suggest for a parent that has a child at, 16, 17, and is approaching having to make that decision?
can I go first, Kathleen? Or
Sure.
because then you get to disagree with me after, right? Instead of the other way around. So, so I would say, we ask the parent, are you just looking to help to be able to continue being a parent, right? Or do you want to help that individual make the decisions, be able to talk to you, Chris, be able to talk to the school system, right? Because many times that's what we find. We ask, well, what's the reason you're looking to? And if it's to get information to help make those decisions, definitely start with the least restrictive. You could give the example, although it's a little, harsh sometimes, is the individual, legally, can they not make any decisions? Can they only make bad ones? I think that puts especially a teacher in potentially a tougher position. I would say, what is the goal? If the goal is to be able to get information and call the doctor, and have those releases and talk to you and be able to get those releases, let's start with the least restrictive and go from there. Or just say, start with the least restrictive and go from there. The school environment says least restrictive environment, start there and move across to more restriction.
Andrew's
Kathleen?
right. I do disagree with him. But right. I think that you as educators and transition coordinators are in a difficult position because people are looking to you for essentially legal advice. Because guardianship, a recommendation of guardianship or conservatorship, or a recommendation of a power of attorney for that matter, is legal advice. These are all legal tools and legal constructs, and role is not to choose for them, or to even, I think, opine on what might be appropriate. What I would do is, I would say these are legal choices. I would recommend either talking to an attorney, or I recognize that some people are intimidated by that. I would provide resources, and I would provide them with the Connecticut Supported Decision-Making Guide, because in that guide, it talks about all of these tools. And so then what you're doing is you're providing information, and then the family is in the position to evaluate the information and choose. And that's essentially what your role is in their seeking your guidance, is to give them the choices.
Okay. I have a couple quick hitters. You ready, Kathleen?
Yes.
Okay. So, we're in an area, Fairfield County, where we have lots of families that come in from other states, other countries, and then move back. Can they pursue guardianship without their son or daughter being a U.S. citizen? Number one. Number two, if they can, does that follow to another state? Can that follow overseas? So if you can kind of just talk about that a little bit.
That's a good question. So in Connecticut, the question of, I don't think that we have a citizenship requirement. We have a residency requirement. So in order for the court to have jurisdiction, the individual has to be a resident in the town where the court is. So I could see that, yes, a court could appoint a guardian or a conservator for a non-citizen who is a resident, because the question of citizenship isn't contemplated in the statutes. There are statutes for transferring guardianship or conservatorship from one state to another. Internationally, I would say that it likely will not transfer. I don't know of any international uniform recognition of guardianship or conservatorship, because every country is different in these models.
Okay, thank you. Are there other questions from our audience tonight? Well, we have Kathleen and Andrew, and before Michael talks a little bit about our next, we're going to schedule another presentation in May, and Michael's going to talk a little bit about that. But any other questions from our folks out there in the audience tonight? I'm going to take that as a no. So Michael, why don't you talk a little bit about session 2 that we're hoping to plan for sometime in May?
So I'm going to only talk briefly because I'm under a tight time frame of window tonight, so I completely apologize. I do want to just say in complete amazement and thank you, because I've even done my own research, and the way you guys have broken this down tonight is quite amazing. So thank you very much. There's been quite a few questions, as I think Chris has mentioned. This year has just been a ton of questions when it comes to these pieces. So I'm hoping for us to schedule something in May, and that would be on the aspect, the conversation keeps on coming up, how families what do they do with money if they are trying to figure out what to do with money, where do they put money? So ABLE accounts, trust funds, financial aspects of how to plan for their children. Kind of also the concept that's come up a lot is when the parent's gone and there's aspects of inheritance, where does that go? How does it affect Social Security? So I literally stood on the phone, no exaggeration, 3 hours and 15 minutes to wait to speak to the Social Security agency to basically not get an answer, which was frustrating, but I tried to do my best to get an answer for a parent. So that's kind of it in a nutshell. The whole aspect of just wrapping the concept of a parent or a guardian trying to think about past themselves, trust accounts, trust funds, ABLE accounts, and what are the best approaches to take. So that's what I'm hoping that we can do before the end of the school year. I think we said that towards a tail end of May, we're going to try to book something. So we're going to collaborate again, if you will, Fairfield Public Schools families and Greenwich families. We're just a town away, a few towns away. This has been fantastic to do this, and I think it hits a lot of points versus even for the individuals and professionals that have to do this twice in a year. So this kind of happened accidentally, and I'm so pleased of how it came together.
Yeah, it has been awesome. Agreed. Andrew, did you want to add something to the ABLE
Yes.
accounts?
Well, so the Able accounts, Kathleen and I have done, oh my God, way more of Able accounts that we've done even of this. So more, I mean, that one I think we could do in our sleep. It's almost more fun if you can imagine. But no, we look forward to do that. And I did also, and Chris, I emailed it to you. I do have a PDF I forgot for the moment I have. And I have a short guide on my site. I put a link to the PDF in the chat. It's a one-page flowchart. Oversimplifies things a little bit, but I do think, and again, it could be guardianship / conservatorship. I think if somebody wants a really simple, and I don't know if you want to pull it up on the screen really quick before we end, Chris. I did just send it to you for people to see. And if you could send that out after, it's just a little generic.
Which
one-pager.
Which one did you want me to send?
The should I apply for guardianship? The PDF. I just shot you an email with it too.
I don't know. Is this coming up?
There we go. Yep.
There it is.
So
how's that? Good?
yeah.
Okay.
So
excellent. I will have all of this information, and Michael has it as well, so folks can certainly contact us. Is there anything else before we leave and close for the evening? Well, I just want to say thank you to Kathleen and Andrew, and certainly thank everyone for spending an hour and 15 minutes with us tonight. As Michael said, Kathleen and Andrew, you put a very complex governmental type of issue. You simplified it, you spelled it out, you gave all the different options. I know I feel much better about things in terms of having a basic understanding. Hopefully some of our, or all of our parents out there as well. But this is a major decision as your son or daughter approaches 18. So please, take the information tonight. Your local probate courts, if for guardianship and for conservatorship, and certainly a local attorney, and certainly Kathleen and Andrew are resources in terms of helping you to make some of these difficult and very, very important decisions that'll be upcoming for your son or daughter. So Kathleen, Andrew, thank you so much for taking time out on your Tuesday night. And unless anyone has any questions, I think we're good for this evening. Thank you so much.
thank you.
Thank you.
All right, take care, everyone. Have a great night. Appreciate it. Thank you.
Thanks again, Chris. Have a good night. We'll talk in a few weeks.